first.
Oh, well, thank you. First of all, it's nice to know that we have so much support. You're like a cast of thousands. I didn't even know I had this army. So this is really good. I would say thank you for coming. I know many of you have traveled, distances to be here today, and I appreciate your coming. I think you're, first of all, seeing something very unique. You're seeing two of us sitting next to each other, and we're actually smiling at each other. And all because we really have one mission, and one mission is to make sure that there is the best teacher in every single classroom in every school in our city. Many of you are parents and grandparents, and what I want to tell you that I take very seriously that any classroom that I would not put my grandchild in, I would not put anybody else's children in. By the same token, there are many teachers who can have an angry parent or an angry this or an angry that bring up charges that may not be correct. But we cannot have people in limbo. We cannot have people who should be working, not working, and people who shouldn't be working, working. And I am asking you to really rethink the whole process of the work that you do. First of all, we want to make sure that you're looking at evidence that matters. Having been a principal who would spend 40% of a given year writing people up, I understand how much time it took me. And if I forgot to cross a T, I literally hired a retired principal to just read my paperwork because it was so cumbersome. And as onerous as some of the charges were, if my T wasn't crossed and my dot, we should not be looking at our work in that kind of detail. We should be looking at what is the problem, and how serious is it, and what do we do as the next steps. So I want to make sure that you're looking at evidence that's relevant to the case. That's your focus, your lens. When I visit a school, I know that there are at least 3 things I want to look for in every single school. And I am focused on that. Principals sometimes try to divert me, and they'll say, look at this and look at that. I want to go back to those 3 things that I want to look at. So what are the things that you need to do to decide your case, and focus on those? Also, I don't know why we need 5 witnesses when 3 will do. The reality is, if something is substantiated, and one person says it, another person says it, and then a third person says it, I don't understand why we need to have a cast of thousands. And I really am asking you, and I don't think that's due process, or it's just a matter of how much longer can this drag out, and I'm looking how much sooner can we get this done. There's a 30-day rule for most things, and I think to the degree that we can do it, I suggest we do it. The other thing is that I think it's really important also to ensure that if there's anything that's standing in the way, at least from my perspective as a chancellor, and you need me to fix it, I'm more than happy to fix it. So for example, you need a witness, you need them to be there at 4 o'clock, you need someone to come from a school. To the degree that I can say to a principal, make sure this person is released when this person has to be there, I'll do that. Because my thing is to get this done as quickly as possible so that everyone's rights are protected, and most importantly, the child who sits in a classroom. And I think we need to do this. And if it means that I have to send someone to convince a parent for the child to be a witness in a case, I'm happy to do that as well. But I also feel that sometimes we wait so long to hear a case that, my memory certainly isn't what it used to be. You can't expect a kid to always be able to do that. So the quicker we do things, the more concentrated we are on getting the case settled, the better we will have a public school system. And both Michael and I are convinced that the only way to have a public school system is we hold everyone to the highest level. I do not want to see some teachers who are getting by on slightly ineffective. I only want highly effective teachers in every one of our schools. And to that I am committed, and I am committed along with Michael to make sure that the 30-20 process is fair, equitable, and reasonable. I do not understand why some cases are dragging on as long as they are. And again, I'll be very personal. I remember having a teacher for 6 months on suspension, going back to the hearing, having the teacher allowed to pick in those days what kind of hearing she wanted, and then coming back to the classroom and actually doing very serious to a child because of the process. We cannot have that. You're on, Michael.
Thank you very much, Carmen, and thank you all for coming. It's lovely weather that we're having here. I just found out that we now have the coldest February in the history of New York City. So thank you all for coming out. I met with some of you years ago, and I want to first thank you for the amazing service that you supply us. These are not easy issues. And we have taken a system that used to take a lot longer, and we have really shortened it. And what you're hearing from myself and the Chancellor today is we're looking to even try to make it faster. Fairness is the key to all of this. The legal processes, I understand at times, can become somewhat of an impediment in terms of efficiency and speed. But what you're hearing us say here today is this is what we would like. And if there is something going on that we should know about, if there is someone on either side, an attorney from either staff, doing something that drags out a case, not doing things properly, not using the full hearing day, we need to know about that. Because we will be looking, because we do believe it is important that if there is any sort of allegation, we want it to take as little time as possible. So, because I do know from being a teacher, from a chapter leader, people who would be completely exonerated but were never correct because they were out of the classrooms for so long and the stigmatism that was tied to that. So we know it's in everyone's interest to have the most efficient, effective, speediest process, as long as we also can ensure fairness, which is a difficult job that we're asking you to do. But I know that we have shortened the timelines greatly from where we were at 5 and 6 years ago, and I can't thank you enough for that. But we're looking now to say, as Carmen said, if there's 2 witnesses saying the same thing, we don't want 10. Okay? And the things that you know better than I do about what else in the process. But more importantly, if you feel that there's something not going right, please let us know. Because we want to know if people aren't doing what we have directed them to do, which is to make it efficient, effective, fair, and speedy. Because that is the way that we feel that will better serve the students of this city. So I can't thank you all enough for what you already have done. I speak very proudly around this state about what we have done here in New York City. And you all know the scrutiny that it is under. And I love that I can produce actual facts to refute a lot of the rhetoric that is out there, and that has a lot to do with your work. So I can't thank you enough for that. But at the same time, we do believe we can even do it better. So at this point, you want questions?
Sure.
Okay.
This is not a typical audience. I get a lot of questions when I speak to principals and teachers and whatever. Not one question? Okay.
Remember the last time we were here? Yeah. Why are we here? Because we want to make sure that everybody understands that we want this process to be done quickly. You are in charge of the process when it gets to your level. And if there are people, if there is something that can be done to make it faster, we'd like to hear it. And if there is a party on either side that you believe is wasting time, we need to know about it.
And I would say also very clearly that for too long, that the head of the education department and the unions were almost expected to be fighting each other. And that this group would say, well, we can't do this because, and we can't do this because. We wanted to be clear here today that we're giving the same message to everyone from both of us. And I think that's really important, and it's certainly something that people outside the organization say, well, you can't do it because of the union, or you can't do it because of the chancellor. We're united on this one. There is absolutely no disagreement between the two of us on only the best people need to be in these positions. So we wanted to say it, we wanted to say it out loud, and we'll probably be repeating that a lot.
And an agreement that was signed 2010. That would be 2010. It said that the Chancellor and the Union President can bring the panels in to discuss this with them, and we just wanted to make it clear exactly what our expectations are at this point.
How are the pro se's getting the transcripts?
Go.
We have an agreement as part of the 2010 agreement that the transcripts are not necessary before you issue a decision or before you do a closing. So the pro se should be getting the transcripts, but it should not be impeding the speed of the process at all.
Not my question. How do they get them? It's on Teach. We have access to Teach. Does the pro se's have access to Teach?
The council should. The council of record.
Pro se.
Oh, the pro se. I don't know the answer to that. I can find out the answer to that.
Come on up. If you have the answer. There we go. Thank you. One in the back.
And I would just say for the more technical questions for the lawyers on both sides who manage the work, you can feel free to stand up and answer like Laura just did.
Oh, she spoke.
Okay.
They have access to that, to the teach.
Well, I would assume, since there are no questions, that everyone gets the message. And again, I just want to be clear that if there's anything that is actually keeping you from doing the job, all you need to do is let us know. Because I am determined on this issue, many others, but this one in particular, that we will get to June with as many cases closed as possible so principals can be assured that teachers they do not want back in the building, or teachers they want to be cleared so they can be back in the building, we can be on their rosters at the end of June.
Okay.
Okay?
So there's no need to have transcripts before a closing argument, is that correct? That the arbitrators should all know that?
Yes, that's correct.
That seems to be a big issue.
Okay.
Okay.
Okay. Well, thank you.
So the in the back, please,
Yeah.
partake
Talk to
and
these guys.
welcome
You-
yourselves. Thank
Yeah.
you for coming.
Do you want to?
Courtney and Ann, if you want to do anything.
Okay. We can go through a couple of more technical things. Okay.
Okay.
We're going to technical. I have to ask you.
Okay, so what I was going to just say is that, to Michael and Carmen's point about making the process be as efficient as possible and still fair, there are a group of things that the DOE and UFT and Courtenaye and I have agreed to over the years about how to make the process run as efficiently as possible without compromising the hearing. One of them, relates to the holding of pre-hearing conferences, which should not be done on hearing days. We should be using hearing days for hearings. We shouldn't be using them for settlement discussions either. The parties are free to discuss settlement whenever they want. Courtnaye and I actively encourage people to settle, but the hearing days should be used for hearings. The pre-hearing conferences should be used to the maximum extent possible to pre-mark exhibits, stipulate the facts, stipulate to admissibility of documents where those things are not in dispute. And discovery should be provided prior to the pre-hearing conference to the extent that that's required by our agreements. We have agreements about what things are supposed to be provided on what timeline, and we have asked that all of the attorneys abide by those provisions.
I think the other thing that we want to talk about, I know that there are more cases that are handled by private counsel, and we're going to be doing another orientation. But I know that it's hard when you have lawyers who may not be used to kind of the groove of things, and they're balancing cases in courtrooms and also trying to manage within this system. Please let us know how we can be helpful to help better integrate them into the system so they get caught up to speed, because I know at times it can be a nightmare for everyone to juggle the scheduling that has to happen, and we want to help get you to a place where the rules for timelines can apply to everybody. So we do know, we are aware that that's been a problem. We're working on it on our end, but I welcome, even though that can be seen as a more technical issue, you obviously talk to the managers that you usually interface with and the lawyers, but you can also reach out to us so that we can help manage that along.
Absolutely, but what I would say is that regardless of who the attorney is, whether it's pro se, whether it's a NICIT attorney who's representing the respondent, whether or not it's another attorney who's representing the respondent, all of the cases should be held to the same timelines, the same 60 days for doing the hearing, the same efficiency requirements, the same everything else. To that end, one of the other things that we have agreed is to the use of full hearing days to the maximum extent possible. That may require either or both parties to have multiple witnesses ready to go in a day. And that is something that we expect both sides of the case to be ready to do. That's something that is written in our agreements and that we believe is an important part of making sure that the full hearing day is used.
I will add, particularly for the DOE, since we have the burden, and we also have the school-based witnesses. As Carmen said, we are committed to making sure that we can work to make things easier to get the witnesses here. Again, everyone here knows that it's a hard juggle to manage what we do down here and what goes on in schools, but I welcome your feedback on that point, and we're committed to making that even more seamless. I know we've made some improvements over the last few years, but we're going to keep looking at it.
Yeah. One of the things that we hear a lot about, Courtenaye and I do, is about the length of particular testimony and who is allowed to testify to what. My way of summing this up has been that grandma is not a relevant witness. We are asking the hearing officers to actively control the hearings, to make a firm, rather than, we know there's a tradition in labor arbitrations to sort of take everything for whatever it's worth and sort it out later. That is not what I think is the best way to be doing business. We think the hearing officer should be ruling on relevancy, ruling on redundancy, ruling on cumulative, ruling on whatever it is, hearsay, whatever it is, to make sure that we're not spending an inordinate amount of time on the testimony of witnesses who don't have anything relevant to testify to or anything additionally relevant to testify to. One of the other things that we've looked at in terms of the process is the use of rebuttal witnesses. We have pretty clearly written out that rebuttal is supposed to be used only for purposes of refuting a fact that an opposing party attempted to establish on its case, and not just for further bolstering the case that one side or the other put on its direct case. And we would ask all of you to please think about whether or not, in the cases that come up before you, whether or not rebuttal is being used for what is truly a rebuttal purpose and not simply to bolster the direct case. We talked about the private counsel cases. The only other thing I would add about that is that even when attorneys change in the middle of a hearing, we totally understand that hearing officers and obviously the UFT and the DOE all want to make sure that everyone has their constitutional due process and right to counsel and all of the other stuff. But it also is not true that those changes in counsel should do anything more than the most minimal derailing of the speed of the case. The only other thing that I have on my list of things that I wanted to highlight for everyone was decisions, and that we've asked the hearing officers to, not only have we asked, but it's in the law, that the decisions be issued within 30 days. That means, look, I've read a lot of 3028 decisions, and some of them are immensely comprehensive, and I know how much hard work and thoughtful deliberation goes into all of those decisions. And certainly we want decisions that are thoughtful and review all of the evidence and stand up to review on appeal. But we also need that to be balanced with the notion that we need the decisions to be issued as timely as possible, because we want the people who should be back at work to be back at work, and we want the people who should be disciplined or terminated to be disciplined or terminated. And it's to no one's benefit for someone to be waiting, reassigned, doing administrative work for a period of time while we wait for a decision. Some of that is necessary. I totally understand that. We'd like to minimize that as much as possible. Anything I left out on our list?
No. So, yes, sir.
If you don't want us to have a pre-hearing conference on a hearing day, what do you suggest we do with the rest of the day on which we have a pre-hearing conference?
Well, I think the pre-hearing conferences should not be held on hearing days. They can be held either on other days of the month. They can be held before a regular hearing starts. They can be held after a regular hearing starts. It concludes. They can be held on a lunch break. They can be held on another day, like I said, but they shouldn't be held in lieu of using a hearing day for a hearing.
In lieu of is your problem.
Yes. No, if you do yeah, okay.
Is there a hand in the back?
Yes, I heard earlier about the party's position that we don't need neither side needs to agree before they close. What about the case, particularly
Well, we trust you to use your discretion. And I'm sorry, I can't see you now. We trust you to use your discretion to manage the process. And, you know, I was a prosecutor for many years. We would have trials where someone's liberty was actually at risk. We were never permitted to actually get transcripts. And for those of you who are trial lawyers on the criminal side, you know what I'm talking about. The judge would say, you were just here, you heard all the evidence, let's go. And so I understand that these hearings don't happen on consecutive dates, but they do happen closely enough in time where we're saying, if you really, some cases might be complex, we understand that, but for ones that are not, you can hold firm, you'll have us to support you, to say, I don't believe that that's necessary or warranted here in this case, and your request is denied.
And right, exactly. And in a lot of these cases, you'll have, I forgot what I'm blanking on the word, but you won't have final transcripts, but you'll have, what's the word I'm looking for? The tentative transcripts. There are, well, I will talk to, Courtenaye and I can talk to the transcription services about whether or not there's a way to get the transcripts to you, even if they're not certified and final, as fast as possible. Let's put it that way.
What about written briefs, though? Do you have a position on written briefs? Should we allow them, should we not?
Again, I don't think, I would never want to manage the process. That's why we have you. I respect your discretion on what you think is necessary in order to have a full and fair hearing on a case. And I think
absolutely. But I think if you were to say, given the case, no, I as a hearing officer don't need a brief, that is not something that inherently either one of us think there's a problem with. There may be occasions where you think it's appropriate to have a brief, but if you don't think it's appropriate to have written briefing, there's nothing that we would say says to you, you have to.
Right. And we'll support you on that.
My personal opinion, I don't even know if it's taken out on you.
Right.
But the point is, if you want these cases to hold up, and in your court, and the lawyer is insisting again, in the process, that I want to file a brief.
Then you can say no.
No, I mean, I understand, but you know on appeal, as long as the facts are there and as long as when the record is reviewed, it's very clear that the person who's acting pro se really did follow and really did understand. I'm not saying that if I wasn't in your shoes, I wouldn't have some trepidation too, because the first couple of cases where you say no, yeah, you're going to wait to see if they take an appeal and what happens. But what we're saying to you is do what's right and what's best and what's prudent for each case. And if you don't need all the extra, do not do it. If it's not appropriate, don't do it. And again, you'll have our support.
Lena, did you have a question?
Yes, sir.
Just a comment about transcripts and such. Offending people, it is essentially unfair that the transcripts from the DOE's direct case tend to arrive prior to the closing, but the testimony of our witnesses often are not in transcript form. Is there anything you can do to think about making sure that's a fair process regarding transcripts? I think we appreciate it.
What you're saying is they're being prepared chronologically, so because the DOE goes first, that comes first, and then you enter. Sure, we'll certainly look into that.
Yeah, I mean, I think that's right, Chris. And I mean, I just think that what Lena said is actually, a fairly good point, which is that no one-size-fits-all solution to any of these cases. but the hearing officers and the attorneys together should be making good faith judgments about what is necessary to do to get the case done efficiently and fairly, and what is not necessary to get the cases done efficiently and fairly, and what is just extra, I guess is the best way of putting it. And the fact that it's a pro se counsel or a non-NICET counsel, pro se respondent or a non-NICET counsel doesn't necessarily, in my mind, alter the analysis so much as what is the nature of the case and what is the nature of the arguments that are being made.
There's a question that came in via over here.
And we won't forget you.
Okay. There's a question that came in from someone who's doing the live streaming. Arbitrator asked the question, when private counsel's involvement in a case leads to scheduling difficulties, it would sometimes be helpful to be able to take the next case out of order. We have been told that that is not permitted. Can there be some flexibility here?
We'll look into that.
Yeah, but I would also say that in general, our agreements are pretty specific that the scheduling of the attorneys is not ordinarily a reason, whether it be a private counsel case or otherwise, for a case not to proceed on the scheduled day.
Yes.
Will I articulate the tentative transcript, please?
I'm looking for the language of the agreement on what we have exactly on this. So the actual language of our agreement on transcripts from 2010 is a party to the hearing or the hearing officer may request an unedited copy of the relevant transcript if a certified transcript is not available when needed. The unavailability of a certified transcript shall not excuse adherence to the timelines for completion of a hearing and issuance of a decision. That's the language of what we've agreed to.
If I ask for it, do I pay for it?
I don't know the answer to that.
Do you guys know?
What's the new agreement that you just signed? Was that any change?
I don't think we have signed a new agreement.
Okay.
Right. So does anybody know, hold your point, does anybody know if there's a cost associated with what we're calling the tentative transcripts?
There's a cost for that, sorry.
Yes, that's okay.
Unedited. Unedited was the word I was looking for.
There's a cost for expedited transcripts. I'm not really clear if what Adam just referred to would qualify as an expedited. And there is a new agreement that's in the process of being signed with the new transcription service. But we'll get some clarity on that and let all the arbitrators know if there'll be a cost involved with getting the expedited, I'm sorry, not expedited, the tentative unedited transcript.
Thank you.
My understanding is we do not, under the new agreement, get copies of transcripts. We go to teach. Accurate?
I don't know, but lots of people who I trust are nodding their heads in the audience, so I'll say yes.
That's a mistake.
I believe that the transcripts are going to be uploaded to Teach.
Yes, that's what I said.
Yes. Where you can get them.
Yeah, I know.
Okay.
Anybody else? Okay, well now I guess you get to
Now
eat.
you can really eat.
And I think we lose the room at 5 o'clock, so you have about 15 minutes to mingle and take your time.
Can we just say one other thing, Courtney, which is that on behalf of the UFT, NICET, the DOE, we're all very appreciative to all of the attorneys on both sides and to the hearing officers. Michael said it, but as practitioners, I think we want to say it too. We know that you all have not an easy job. You all have the attorneys have the job of being zealous advocates. The hearing officers have the job of being neutral referees. It is not easy, but you all do on a daily basis a vital service and can really deserve a lot of appreciation for the work you do.
Thank you. Thank you very much.